Hey guys, welcome to the Criticisms and Reforms essay on non-fatal offences. Before I start this video, I'd just like to say that if you don't want to hear my dull, boring voice for, I don't know, any absurd reason, there's going to be a download link in the description to this essay. But if you do want to hear my voice, there's a cup of tea in the corner, and I think there's jammy dodgers next to it, so grab a cup of tea, get some biscuits, and we'll get started. Start off by the actual question that you might get in the exam. Consider what criticisms may be made of the non-fatal offences against the person. Discuss what reforms might be introduced to deal with these criticisms. 25 marks. This answer that I'll give you here is a sound, so it's 100% got the details that are necessary. You can get 24 or 25 marks on this depending on the examiner, or 23 if their cat died and they're having a bad day. But generally, I'll go through it quickly and show you what the points are and what you can include in yours. So let's go. The first observation to be made about the law on non-fatal offences is that it is not completely codified. The separate offences of assault and battery remain common law offences, albeit with their separate nature confirmed in Section 39 Criminal Justice Act 1988. The more serious offences such as assault occasioning actual bodily harm, wounding and inflicting grievous bodily harm, and causing GBH with intent are contained in the Offence Against the Persons Act 1861. So that just shows that there are two separate laws for the actual offences. So the Offence Against the Persons Act and the Criminal Justice Act 1988, and the sections that are different. Even at the time of its passing into law, the 1861 Act was rightly described as a rag bag of offences by its own draftsman, and as it is now nearly 150 years old, the criticisms are even more acute. Some of the language used is now archaic. Grievous bodily harm simply means harm and occasioning actual bodily harm, which commonly means battery or some harm to a victim. As to case law, the definition given to wounding in JCC versus Eisenhower, which is any breach in the outer and inner layers of skin, is far too wide and can cover anything, including a minor cut or even a graze. An interesting contrast can be made here in regards to the Theft Act 1968, which was intended to codify the entire law on theft. Within 10 years, a further Theft Act had to be passed, and there had been significant statutory additions and amendments since. Yet, the 1861 Act remains unamended, except by judicial intervention. So here it tells you about how the offence has issues with language and linguistic features, and gives examples in terms of cases to definitions of wounding. Moving on. Other linguistic criticisms arise over the word assault and battery. Although assault is technically used to describe causing the victim fear, the use of unlawful personal violence, it is most commonly understood to refer to some sort of physical attack. The strict definition of battery is unlawful touching, and no injury of sort is required. So this basically gives the outline that the words used create confusion amongst people. So assault and battery in terms of the linguistic criticism. Probably the most serious criticism of the 1861 Act concerns the issue of the mens rea for each of the offences. Section 47, which deals with ABH, are entirely silent on the issue of the mens rea, and it has been left to the courts to determine what the mens rea is. The case of R.V. Savage and R.V. Parmenter, now confirm that the mens rea of assault and battery, intention of subjective recklessness, is all that is required. In Section 20, the word malicious has been interpreted so to mean intentional recklessness as to causing harm, which was stated in R.V. Moore and R.V. Grimshaw, which is related to wounding. In interpreting Section 18, judges and academic lawyers have concluded that malicious is effectively redundant except as regards the secondary mens rea to resist arrest. So the word malicious has been taken out, and the fact that the secondary mens rea to resist arrest has been left in. This goes back to the most serious criticism of 1861, mentioning 4 cases in regards to section 20 and section 47. So this is a very strong point which you can argue. A further point of criticism is that the Act is now undergoing almost perpetual revision and rewriting by judges, which could almost be called law making by statutory interpretation. The 2003 case of R.V. Dekar, which I should highlight in blue, which involved the defendant being convicted on biological GBH under section 20 after infecting 2 women with HIV, is another good example of the ability of senior courts to amend the law. The Court of Appeal, having quashed his conviction and ordered a retrial, confirmed that injury by reckless infection does constitute a section 20 offence, and that R.V. Clarence, where a husband was prosecuted for infecting his wife with gonorrhea, was overruled on the same issue of direct bodily violence being required. The most significant part of this judgment relates to the defence of consent, as the court rules that the victims knew or suspected the defendant was infected. No criminal liability would arise. So this generally contrasts 2 cases. So R.V. Dekar, where the person was prosecuted for infecting with HIV. However, in the case of R.V. Clarence, it was overruled as there was no direct bodily violence. Given the judicial decisions in R.V. Savage, section 47, and R.V. Moat, section 20, it is clear that these 2 offences now involve constructive liability, making it unnecessary for the Crown to prove intention or recklessness as to the actus reus of the offence. Conviction under section 47 can be obtained by proving that ABH was in fact caused by common assault or battery. For neither of the offences is there a need to prove that the defendant was intended or was reckless as to causing any level of harm at all. The issue of constructive liability militates against the basic principle of criminal liability called the principle of correspondence. This requires that the mens rea should be related to the actus reus of the offence and to the possible consequence of being convicted of this offence. It's another good point to write about the constructive liability. Finally, the hierarchy of sentencing can easily be criticized. Both assault and battery have the same maximum sentence, 6 months. Section 47 ABH, which states the mens rea for which only any hurt or injury interferes with the health or comfort of the victim, that states the definition, carries a maximum sentence of 10 times the level, 5 years, which is exactly the same as that for section 20 wounding and inflicting GBH. These maximum sentences lack even a semblance of consistency and coherence. This goes back to the sentencing aim, how long the sentence is basically, and the fact that they're not coherent and they don't correspond to what it's saying is a bit flawed. It is evident that there is an indisputable case for the complete codification of law and on non-fatal offences, but even the Commission's 1994 recommendations for the reform did not include the common law offences of assault and battery. These recommended reforms included and created the following new offences. These are the reforms basically: intentionally causing serious harm, recklessly causing serious harm, and intentionally or recklessly causing some injury. So there's 3 new reforms with new offences that goes together with the serious harm aspect. Then you end it off: although those recommendations have not been welcomed by all governments since, no actions had been taken to incorporate them into any of the major criminal justice acts passed since. So it states the proposed reform and states the outcome of that reform, which there was really no outcome. So I'll say again, I'll leave this in the description and you can download it, go through it, it'll be all highlighted and everything. You can make your own amendments to it basically, because I know there's some grammatical errors, but this goes with: consider what criticisms may be made of non-fatal offences against the person, discuss what reforms might be introduced to deal with these criticisms. Like I said, sound answer, 24-25 marks, generally good structure and layout. What I would do is I wouldn't actually remember the answer word for word. I'd remember the main points and what cases go with those specific points, and then expand that in your own words and whatever you know as your own knowledge. But that's basically about it. That's one criticism question done, and hope you've learnt something, and yeah, that's about it. See you guys.